Start. By this writ petition, the petitioner has challenged judgment and order dated 23/2/2018 passed by the Court of Additional Sessions Court, Appellate Court, whereby appeal filed by the respondent has been allowed and the decree of possession granted in favor of the petition by the Court of Joint Civil Judge Junior Division has been set aside. The petitioner filed suit for possession and recovery of rent in respect of a shop, claiming the said to be admeasuring 395 square feet given on rent to the respondent from 11/6/2008 for 11 months up to 10/5/2009. It was claimed by the petition that the said agreement was in writing executed on 2/9/2008 for the aforesaid period, and it was attested before the notary on 19/9/2028. As per the said agreement, the aforesaid shop admeasuring 395 square feet was given on rent for the aforesaid period of 11 months to the respondent for an agreed rent of rupees 319 per month. The petitioner claimed in the suit from November 2008 the respondent failed to pay agreed rent, as a result of which the agreement had come to an end, and thereupon the respondent was illegally in possession of the suit shop. As per the petitioner on 27/7/2009, a notice was issued to the respondent stating that he had defaulted in the payment of rent from November 2008, and further that he was illegally in possession of the suit shop beyond the agreed period of 11 months. On the basis, possession was sought from the respondent. As the respondent did not send any reply to the said notice on 23/9/2009, the petitioner filed the aforesaid suit on 31/12/2009. The respondent filed written statement in the aforesaid suit denying the execution of the agreement while denying the claim made on behalf of the petitioner in the suit. It was specifically stated in the written statement that there were actually two shop blocks, one admeasuring 200 square feet and other admeasuring 195 square feet. It was claimed that the respondent was put in possession by the petitioner in the shop admeasuring 200 square feet from January 2006 from a monthly rent of rupees 2000, and a deposit of rupees 50,000 was also made by the respondent. Thereafter, in 2008, the respondent was put in possession of the other shop block admeasuring 195 square feet at the monthly rent of rupees 1500, for which a deposit of rupees 30,000 was made. It was also claimed that there was an oral agreement regarding each tenancy for a period of 10 years. It was also submitted that there was no default in payment of rent on behalf of the respondent, and therefore there was no cause of action to file the present suit. Para. The parties laid evidence in support of their respective claim as per their pleading. Upon taking into consideration the pleading evidence and material on record, the trial court decreed the suit in favor of the petitioner. It was held that the agreement was proved by the petitioner, and since the respondent had continued in illegal possession of the said suit shop beyond the period of 11 months, a decree for possession was passed in favor of the petitioner. Para. Aggrieved by the judgment and decree passed by the trial court, the appellant filed appeal before the appellate court, inter alia contending that since the agreement said to have been attested before the notary on 19/9/2008 was not a registered document, it should not have been looked into by the trial court. It was submitted that such an agreement was mandatorily required to be registered under section 55 in bracket 1 of the Maharashtra Rent Control Act 1999. The requirement for getting such rent agreement registered was the responsibility of the petitioner landlord, as per section 55 in bracket 2 of the said act, since it was not registered as per section 55 in bracket 2 of the said act, the contention of the respondent about terms and condition of the tenancy would prevail. Apart from this, it was pointed out that the oral evidence of the petitioner, particularly admission given in the cross-examination, demonstrated that the decree passed by the trial court was unsustainable. Stop.